our brilliant young underwriter, Tebe, to take over and run through this with us today. Thanks, guys. Tebe just needs to unmute for a second, then we'll take it from there.
Good morning, everybody. Am I audible? Am I audible? Can you guys see me?
Yes, we can see and hear you.
All right, perfect. My name is Tebe, and I'm a medical malpractice underwriter at iTOO. I've been with iTOO for 4 to 5 years, started as an intern in 2018 to the position that I hold right now. Academically, I have a master's degree in applied development economics, but my greatest achievement in life is that my mom really loves me. So the topic for today, or a theme for today, is summons, not what the doctor ordered.
Thanks, Debbie. I think the biggest challenge from our side is that when we get a summons, our doctors immediately panic, and we find ourselves having our doctors not certain of what to do. If we were to take it through our policy response and what we can provide cover, no practitioner goes into a theatre or provides treatment with the intention to cause harm. We, at this moment, and will always provide cover for HPCSA defence costs. Unfortunately, fines and penalties under the HPCA is not covered by the policy. We would also provide cover for defence costs should a claim arise due to negligence, and instances where there has been concessions or merits found, the policy would provide cover for awards and damages in that instance.
Good morning.
Sorry. Nadia.
Good morning, everyone. Thank you so much for joining us this morning. If anything, I can say things have changed so much over the years. People, from what we've seen, people have become so much more aware of their rights. And where they believe that they've been wrong, no longer are they willing to accept things as is or let things slide. Gone are the days where you may have a case where a doctor unnecessarily or accidentally cuts off a person's finger. We're definitely not going to see a patient thinking, okay, the doctor made a mistake. At least I've got 9 other fingers. The fact that they are so aware of their rights, they know that recourse can be taken against the practitioner that has wronged them. What we do find from the claim side is that before actually embarking on the legal route and where summons is issued, we do find that doctors are on the receiving end of direct complaints from the actual patients, complaints lodged against them with the relevant regulatory and statutory body. We find that we also see a lot of patients actually claiming compensation for damages. And what we've seen a huge increase in the past few years is a spike of what I like to call phishing expeditions in the form of a request for records where patients are requesting information. Where a practitioner is on the receiving end of any of these types of approaches, we always encourage a practitioner to give notice to the insurer as soon as possible. One, this is to ensure that they comply with their notification obligations under the policy. And secondly, when it reaches our desk, we can then have a look and see whether there's something that needs to be done and how we can assist and guide and ensure during this time. Over to you, Tabs.
All right, perfect. This is a question to Justin and Sandra. As attorneys, you live, breathe, and sleep litigation. Dealing with third parties and plaintiffs is something that is not new to you. Tell us, why do patients sue?
Thanks, Tabs. Well, my colleague Sandra is still trying to join us. Let me kick off by saying, yes, that is a question I think that particularly our insureds may lie awake at night thinking about, is why on earth have I been the recipient of this letter of demand, or why is this patient chosen to issue summons? But as you pointed out, that's nothing new for us in our line of work. We do it morning, noon, and night. So the purpose really, I suppose, is for us to share with you some of our insights as to the reasons why we get to that stage. Why do patients ultimately elect to sue? And in my experience, there's 3 main reasons. Sometimes they work together, sometimes they work alone. The obvious one being physical trauma. if a patient has suffered some form of physical trauma, it means that the treatment experience was painful. I went to you to have a knee replacement because I was already in pain, and I come out of theatre and I found out that you've operated on the wrong knee. That immediately means additional physical pain for me, because I'm going to not only have to recover from that surgery, but undergo another one on my other leg. Also, where patients have stayed in hospital for considerably longer than they expected to be in hospital, or was their expected recovery time due to complications or things that happened. So this experience of physical trauma is often a primary motivator for a patient to seek some form of recompense. The other, and not to be discounted, reason that sometimes can be the biggest reason is hurt feelings. We're all emotional beings, and sometimes patients just feel that they were not heard. They were not heard by the clinician. They were even possibly disrespected by the treating practitioner. And this impairment of their dignity, so to speak, leads them ultimately to go and seek legal advice with a view to making some form of claim. And then we live in a material world, said Madonna, and where we lose money, it's a big deal. And for many people, having to pay extra because they had to undergo additional tests or additional surgery, additional length of stay in hospital, these are all things that if a patient sees, well, I was told I was going to be in the hospital for 5 days, I was now in hospital for 15 days, and I was in ICU, none of that I expected to have to pay for. That so-called unnecessary treatment often forms the basis of a claim. And of course, some of these issues work in concert together, and they're more acute in cases where a loved one claims on behalf of another. So for example, often we find that a parent will claim on behalf of a child because their feelings of injustice or the bitterness they feel about a treatment that went wrong or didn't have the desired outcome is just so much more acute. So we must remember that we as clinicians are there to treat the patient, but the patient has loved ones that care very deeply for them, and we need to take cognizance of them in the treatment interactions. We're talking here about reasons why patients sue, but perhaps for a second I should just mention that, well, you might ask yourself, well, why is the motive important? I mean, a claim is a claim. Well, in fact, the motive to sue does influence the defense strategy that we adopt as attorneys who iTOO appoints on these claims. The reason is that if you are dealing with a litigator of principle, so to speak, it's the right of the thing that concerns them. You're going to deal with it differently, and you're going to have a different experience in adjusting that claim to one who's just out to make a quick buck. The same consideration also influences the length of a claim. So if it's an emotional issue for a patient or their family member, it's personal. It's something that will cause them to hold out longer to see justice done in their mind's eye. So these are factors that do ultimately influence how one deals with a med-mal claim. It's a nuance that's perhaps unique to this area of professional indemnity insurance as opposed to other areas. And of course, we mustn't forget that at a broader societal level, Nadia hinted at it, I think, and Fia in their introduction. You know, we now live in an age contrary to the past where we've got the Consumer Protection Act. Patients are very aware of their rights to fair dealing in the provision of goods and services, and medical services count as services for purposes of the Consumer Protection Act. So one must remember that this awareness of rights is propelling a greater sort of sense of responsibility that patients have to protect their rights and that of their loved ones. And another point I suppose to make, and perhaps it's an indictment on my kind, but you do have attorneys out there that make their entire living just off chasing ambulances, so to speak. So it's their bread and butter. So of course, they are going to be the ones responsible for driving these type of litigious claims. So those are some important reasons why I think patients choose to sue. And remember, of course, that nowadays it's not just about the suing. It's about all forms of legal redress. And Nadia, you hinted at it in your introduction. The fact that patients have a variety of avenues available to them to seek redress. Sometimes as a precursor to a claim for monetary damages, they do choose to report the matter to a regulator, such as the Health Professions Council. That's typically in cases where a patient feels that there's been a breach of ethical standards or professional standards. The test in that forum is very different to the one in a lawsuit before a court of law. However, often patients seem to adopt the approach, well, I'll take my chances with the regulator, and if I get a good finding, a good outcome, then it's sort of an extra feather in my cap with which I can then go and pursue a summons against the doctor. There are other regulators to look out for nowadays. For those of us that insure and underwrite health establishments, there's the Office of Health Standards Compliance that performs a similar oversight role in respect of norms and standards that apply in public health establishments. They are also empowered to investigate complaints of breaches. And there's even other novel forums nowadays that we're starting to see. Patients report matters to the Equality Court, which was a first for me when I saw it a few years ago. The Equality Court is a type of high court that is established under the Constitution to protect the rights specifically in Section 9 of the Bill of Rights. So that's the right to equality and to be free from discrimination on any of the listed grounds. So nowadays, patients even consider going before the Equality Court if they feel that they've been discriminated against in a treatment interaction. And of course, where a patient dies, we have the Inquest Act that applies, so judicial inquest to determine the cause of death. Often this will be pursued by family members if they are unsure of what happened or don't understand, or they suspect foul play by anyone in the final treatment setting surrounding their loved one. And essentially that's reserved for persons that want answers. It's a very cumbersome process. It's a very expensive process. But it's regulated by statute. So unfortunately, once a patient dies of what's regarded as an unnatural death, the law has to take its course. So in all of those instances, a practitioner should most definitely make use of legal representation, because there are nuances to each that can leave a practitioner very exposed.
Justin, have you seen an HPCA matter run concurrently with civil matters along with occupational health complaints?
We have. It's quite frustrating, and it's something that we've sort of got a running battle with regulators like the HPCSA, because our belief is that you shouldn't have to defend yourself in more than one forum at the same time, bearing in mind that pronouncements or statements that you give in one forum may very well be used against you in another. The biggest concern, in fact, is not running civil matters concurrently with anything else, because that's purely about damages. The bigger concern is where a patient has passed away and there is an HPCSA complaint against a doctor as well as an inquest. That presents considerable risk to an insured doctor, because bearing in mind that under the Inquest Act, all persons of interest, so to speak, or persons that have to come and give witness testimony are put in the position of a quasi-accused for purposes of the Criminal Procedure Act. Bearing in mind that one of the findings that an inquest court can make is that someone criminally negligently contributed to the death of a patient, and that would arm a prosecutor with a right to prosecute for culpable homicide. So the stakes are very high there, and we have to work very carefully with insureds and their insurers to make sure that their rights are protected while those two processes run concurrently.
If I may just add to that, can you hear me? Oh, perfect. Hi, everybody. For the record, my name is Recital, not Justin Malherba, obviously. But just to add to what Justin has said now about the HPCSA running concurrently with civil litigation, usually what happens is the HPCSA complaints or inquests are precursors to civil litigation. So it's not often that they run concurrently, but it does happen. But what we have seen actually is when the patient first goes to the HPCSA to see what their chances are, and then use that in the civil litigation. But of course, there's no monetary compensation in HPCSA inquiries. So usually they just eventually tend to gravitate towards the civil action. And maybe also just to emphasize on 2 points that Justin raised about the reasons why patients sue. I mean, Justin, you did touch on it, but at a general level, there is an increased awareness by people of their rights to sue, and that is brought on by the Consumer Protection Act, which Justin mentioned. And as you would know, the purpose of the Consumer Protection Act is to protect consumers and to emphasize or promote consumer education. So certainly in the last 20 or so years, we have seen a marked increase in litigation because people now are aware of their rights and are not afraid to exercise them. And then a second point, talking about attorneys, what has exacerbated things is when the well dried up in road accident fund matters a few years ago, suddenly every personal injury lawyer in town fancied themselves to be medical malpractice specialists. And the problem with that is what most people don't realize is that where there is harm or where there's a complication arising from a medical procedure doesn't necessarily mean that there is negligence. But obviously you can't tell that to a patient whose feelings have been hurt, or even worse, to someone that's financially motivated. And that's not to say that there aren't cases that are meritorious and deserving of compensation, because they are. But unfortunately, there are others that are not. And our job as defense lawyers is to sift through the good from the bad and to ensure that each case is dealt with properly on its own merits.
All right,
Thanks.
Thank you very much, Justin and Sandra. It's just question 2 now. Receiving a legal document is no joke, and I'm sure it's quite stressful for a practitioner or facility cited to proceedings. What happens when a practitioner or facility is sued? What should be done? Have there been instances when a summons has been ignored, and what has followed?
Yes, well, that red telephone that we see on the slide there, Tebo, that telephone is red for a reason. The first and most important thing that we need to teach our insureds is that when you receive any form of approach containing elements of a legal demand or an approach by an attorney, is you notify under your policy, which requires that you notify your broker. There are specific reasons why insurers such as iTOO insist on that. The policy typically provides that as soon as one becomes aware of not only a claim constituted by legal documents such as a summons, but also any circumstance that is likely to give rise to a claim, one must notify the insurance. And typically the timing on that under most policy wordings is as soon as reasonably possible. So obviously that leaves an element, the element of reasonableness means there's a period of time, but bear in mind that insurers have a right under the policy to investigate the matter as soon as possible and to put in place contingencies to reduce the risk of loss. So for that reason, and also for evidential reasons, it's very important that insureds notify as quickly as they can. And typically that means that they tell their broker, and their broker will email iTOO, and iTOO will open the matter on their side. The next thing that would obviously happen is a policy response by the insurer. And if there has been a summons served on the insured, iTOO will appoint an attorney to represent their insured's interests. Typically, the initial response to a summons would be for an attorney to contact the insured and then arrange to enter a notice of appearance to defend on their behalf. So that is sort of the opening bet, if you like, once the roulette is in play. And there are time periods applicable to that notice, and hence again the reason to notify as soon as possible, because iTOO still needs time in order to make these decisions under the policy and to make an appointment of an attorney to represent the insured. Typically the time period applicable is 10 days from when a summons is delivered on an insured. and it's 10 court days, which for all intents and purposes are business days, so 2 weeks. So that would be the next step in the process. And then under the guidance of the attorney, the insured must take steps to do two things: secure the evidence and secure the witnesses. So securing evidence means getting a hand on any physical or documentary evidence relating to the subject matter. If the complaint relates to a faulty machine, take that machine offline and put it in storage so that it can be inspected at a later date. If it relates, say, to monitoring in a hospital environment, the original CTG scans in an obstetric unit are very important. Those need to be secured as soon as possible. And also the witnesses. I know it sounds ridiculous, but these matters, because they can take many years, witnesses float away from us, into the ether, or they go and work overseas. So one has to get contact numbers for people, email addresses. So if they do move around over the lifespan of a matter, you can continue to contact them as need be. Do you agree, Sandra?
Yeah, definitely. I mean, with the witness points that you raise is very important because you can have the best defense case in the world, but without witnesses and without the evidence, then that doesn't help at all. So securing witnesses is very important. I just wanted to add something else about letters of demand. So you will see that sometimes you receive the letter of demand, sometimes you don't. From a legal perspective, that doesn't mean anything because a summons in itself constitutes demand. But from a strategic perspective, it always helps to have a letter of demand before you get a summons, so you can do all the things that Justin has mentioned in terms of securing the evidence and securing the witnesses. And remember, by the time that the plaintiff institutes summons, they've done their homework already. Sometimes they've even lined up experts. And as the defense, we always find that we are in the back foot in terms of trying to catch up with the plaintiffs, with our investigations, with the liability investigations, etc. And it always helps to have that letter of demand before summons is issued, because then the strict timelines apply: 10 days to enter an appearance to defend, and 10 days, 20 days to file a plea. So we want to receive letters of demand. And there are sometimes matters that get settled at demand stage before you even get to summons. So we always like to receive the letters of demand. Tebe, you mentioned in your question that what happens if you don't enter, if you don't defend? Well, the worst happens is that the plaintiff gets default judgment against you. So if they're claiming 30 million, they get default judgment for 30 million. And you are, well, as a doctor or medical facility, you are liable for that, and your insurers won't cover it because you didn't notify in time. So you certainly do not want to not respond to a summons. Of course, you can always rescind a default judgment order, but that's costly, firstly, and secondly, you need to have valid reasons why you didn't defend the matter when it was first instituted against you. Yeah, thanks.
Thanks, Justin and Sandra. What is the process to establish liability and the pertinent issues to navigate the way forward?
Sandra, if I can kick off, I think, the liability we're talking about here, and the liability that triggers coverage under the policy, is a legal liability to pay damages. So first and foremost, our role is to investigate the matter, the merits of the claim that is being proffered by the third party, the patient or plaintiff. And that essentially means starting with the facts. One needs to establish what are the facts underpinning the dispute. And to do that, we typically consult with witnesses to the events described to find out what they know, what they saw, what they heard. Then one has a look at any documentary evidence, the documents, the clinical file of the doctor, have a look at the hospital records, if there was a treatment interaction in hospital, perhaps correspondence that was exchanged between the patient or the family and the practitioner. And oftentimes it also involves an inspection in loco, if you like, which means going to actually physically view the scene. If this took place in an operating theater and it was a unique procedure with a lot of working parts. Sometimes it's necessary for attorneys and also the advocates that represent insureds in lawsuits to actually go and view the scene to see how it all works. Only once you know those facts well enough are you in a position to apply the law to determine whether there is liability or potential for liability attaching to the insured in this instance. And to do that, one of the things that makes medical malpractice a unique area of well, not unique, but amongst liability insurance, quite complex, is the fact that it's very expert evidence rich. In order to get to a view on liability, often one has to rely on the input of experts in the field of endeavor, either of the practitioner concerned or the subject matter of the dispute. And that presents some unique challenges on its own. I don't know, Sandra, if you want to take us through some of those challenges.
Before Sandra takes over, Justin, we know that we've been facing a challenge in South Africa specifically, where practitioners unfortunately have passed away due to COVID, being on the front line, and many practitioners are immigrating due to the fear of the NHI. What's the challenge in finding the right expert for the right merits and matter that needs defending?
Well, it is an immense challenge. I don't know, Sandra, were you going to?
Yeah, I was going to address that. Maybe you can add as well, but it goes to your question that you asked about experts. Fear, it's very difficult because there's only I mean, if I compare to 10, 15 years ago, we had so many experts in various fields of specialty, and I mean, we had really a good hand to pick on. But now that's changed completely. You mentioned immigration, you mentioned COVID. There are, in addition to that as well, there are experts now that simply say they're no longer interested in doing any expert work. So it is a challenge, and it's one that we have to work with. The immigration one, I'm not so concerned about, because what COVID has done, or lockdown has done, is to get our courts to jump onto the online platform bandwagon. So it's easy to now get an expert. For example, with CP cases, we used to have experts that sit in the US, and it took time and cost to fly them over to give expert evidence in court. Now we can do it online. It's shown that it can work, and most people are using that. Are using experts via online virtual platforms. So that I'm not too concerned about. What I am concerned about is the dwindling number of people, of experts that want to do expert work. We just, I suppose, just need to keep in touch with the ones that still do. And the problem, though, is that the ones that still do don't have time to do expert work immediately as you give them the brief. It takes months. I have one matter where last year I asked for an expert. It was a pediatrician, and he said the only time he could accommodate me was this year in August. So you just have to take your chances in terms of trying someone else, or waiting that long for your experts to become available, and that obviously contributes to the delay in seeing the matter coming to an end. Justin, do you want to add something maybe there about experts?
I totally agree, Sandra. It is very tricky, and it makes our lives as attorneys very difficult, because we are then placed in an unenviable position where we have to advise insurers as well as the practitioners themselves to either wait it out so that we get evidence that we know will be useful for our purposes, or go elsewhere or try. We've even seen nowadays a lot of plaintiffs, for the same reasons possibly, go overseas to look for expert opinions to back up their claim. The difficulty with that is, depending on the specialty, if we're talking about the practice of medicine, the standards may be different in the context within which the expert operates. So if you go and get an online opinion from a professor of surgery in Canada, or in California, he might well take a different contextual view of the problem as would a professor from a South African university who is aware of what the position is like on the ground. So, you know, there are pros and cons and risks associated with trying to move the matter along in that manner. But at the end of the day, it's our job to advise insurers such as iTOO on whether to wait or whether to pay an experiment. But yeah, we are a conservative bunch. So Sandra and I value the relationships that we do have with experts who are willing to provide us with opinion as soon as possible.
Yeah, maybe just to add on to that, something about experts that I wanted to mention is that when we approach experts, we don't want hired guns. We don't want someone that's going to tell us what we want to hear, because we've seen plenty that with certain experts that are known to only act for plaintiffs and certain experts that are known only to act for defendants. We want someone that is independent and that will give an objective view on the facts and the liability exposure, because then firstly, you don't want a hired gun because they tend to always crumble in cross-examination. So firstly, you don't want that. But secondly, we want to know what the liability exposure is as soon as possible. So tell me what the facts are and what my exposure is now. That helps me defend the matter better, and it helps me make recommendations to insurers whether we are gone for or we are very bad on the merits, and then we can assess the quantum properly in terms of making an early settlement. And by that way, we avoid the legal costs. I see in the slide there's an issue of merits concession. I don't know if we are going to get to that, but I just wanted to mention we never ever concede merits until we are, we absolutely have to. The problem with conceding merits is that once you do that, then the quantum just shoots up because the liability has been established, you have conceded, and the plaintiff attorneys rather just run crazy with quantum. I had a matter before that was, I think it was about 8 million rand claim. And once the liability portion of the matter was determined, I mean, we had to concede in that one eventually. The quantum shot up to 30 million. So as far as possible, try not to concede merits. You can still settle the matter without conceding liability, because that can be done on a without prejudice basis, on a without liability, admission of liability basis, and as a commercial settlement as you would have it, and both parties walk away happy. And Justin, I think you have raised the point before that sometimes conceding merits is tantamount to admission of guilt, and most doctors do not want that on their record. So try and avoid that as far as possible.
Sandra, I mean, we must remember the context within which the claim is being brought under a PR policy is the fact that doctors are professional persons. Their reputation is very important in the environment in which they work, and especially if they ever intend to work overseas. One of the interview questions they are asked is, have you ever been found guilty of unprofessional conduct? And secondly, have you ever admitted guilt? Which is a similar word to liability. So yes, we most certainly prefer the without prejudice and without admission of liability route when it comes to adjusting claims where the merits are dubious.
All right, thank you very much, Justin and Sandra. Individuals believe that when they are cited to proceedings, wish that these matters could magically go away and that they can be resolved in a matter of a few days or a few months. This we have seen is not the case. What contributes to the long tail of such claims and the resolution thereof?
Contrary to popular opinion, it's not because lawyers are so long-winded. It actually has to do with other factors. Look, the reality is that a medical malpractice lawsuit can take, on average, at least 2 + 2, in other words, 4 years to resolve. We say 2 + 2 because typically the liability portion the merits of the dispute are adjudicated first, and that can take up to 2 years to get a court date. That was even before COVID. And then once that's established, if there's still going to be a determination of the damages, in other words, what the claim is worth in money, that would take a further 2 years to get a second court hearing. And many people, I mean, for obvious reasons, it's very frustrating in our environment. But the truth of the matter is South Africa is not alone in this regard. There are many jurisdictions over the world where it takes even longer, up to a decade for matters of this nature to be finally adjudicated. The ultimate question is why? Why so long? Well, we spoke earlier about the fact that often the merits of a dispute are dealt with separately from what it costs in money. And that's actually because the court rules favor such an approach. There's a rule in our rules of court which requires the parties to, where convenient, separate issues of liability from issues of damage or the quantum, what it's worth in money. And just to give an obvious example, this would be convenient, obviously, especially to a defendant doctor, if he is good on the merits of his defense, and if he succeeds at a first hearing in convincing the court that no liability attaches to him in this instance, that's the end of the matter. So he gets out after 2 years. Whereas if you had to prepare on the quantum of damages at the same time, that would lead to immense extra expense, which is now unrecoverable because you've been found not liable. So it makes sense, and hence the convenience principle applies, convenience to the court and to the parties. It's less expensive that way, but it does take longer. So that is one of the reasons why these matters typically take so long. And that was before COVID made things very difficult for all of us, including the court system that is still in many areas of the country laboring to get back to levels of service that it was at before the pandemic. So we're hoping for an improvement, but yeah, we'll just have to hold those thumbs a little bit longer. Sandra, I think you want to tell us a bit about how the interruption of prescription works.
No.
Oh, okay. Well, I'll add a sentence about that.
Well, I can talk about prescription, that's fine. So prescription is, well, as you know, in terms of the law, you have 3 years to institute a civil action from the date on which the cause of action arose. I don't have the legislation in front of me, but there's a typical wording which says that when you know of the identity of the debtor, which is almost always easy to ascertain, so you know who cut off the wrong leg. And the second portion is, if you don't know, if you've taken active and reasonable steps to become aware. So that's the legislation relating to prescription. But as you know, for minors, I think it's about, what is it, Justin, 18 plus 1. So that's longer, and that goes to the issue of record keeping, which I'm sure we will get to later, because you need to keep your records, at least if you have dealt with minors, up to at least 19 or 20 years. But that's prescription generally means you need to institute your action within a certain time period when the cause of action arose. I've seen lots of policies where you have the legislative prescription, and then you have what are called time bar clauses. So those are different to the prescription as we know it, but have the same effect basically. So it means that the ones I've seen is the insurers will say you have 6 months, for example, to lodge an action or whatever the case may be. There are limiting time periods in terms of which you can actually bring an action. But the general one is 3 years and 18 years plus 1 for minors. Is there anything in particular that you wanted me to speak to about prescription? Justin? Or was it just that at a general level?
No, I think that's right. And sometimes that's the question that the doctors are left with in their mind is, it's been 3 years since I treated this patient. I can barely remember the patient interaction, and here comes the summons. Why have they waited so long? Well, there's your answer, as Sandra said. to interrupt prescription. The attorneys perhaps sat on the file and diarized it and thought, okay, well, we're not sure whether or not there's a valid claim here, but let's take our chances. And so
I have one matter, sorry to interrupt you, I have one matter where cause of action arose in 2014. 2015, they instituted action right on the verge of prescription. So 2017, and then sat on it, didn't do nothing at all. I mean, did nothing rather for 3 years until we had to push and say, either you withdraw the action or we take active steps to get this matter to trial. And suddenly the attorney is now the best lawyer in town, and he's the one that's doing everything. But that just goes to show you that sometimes it's just about interrupting prescription and not so much as they think that they have a valid claim.
Here's a question to both yourself, Sandra and Justin. So you've been doing this for years. What's the longest claim that you've dealt with?
I have one matter that's still active to this day. Thankfully, it's not an I2 matter, but I started working on a medical malpractice as well. I was a second-year candidate attorney, and that's like 16 years ago. So for me, that's the longest one, and it's still active. The plaintiff is, well, the facts, I mean, I'm not going to disclose the names, obviously, from a confidential perspective, but just briefly, the facts are the plaintiff's wife passed away at a medical facility. Then he instituted a loss of support claim. And he has done nothing. I'm not even sure if he's still alive because I've never dealt with him. He had attorneys who withdrew as his attorneys of record. And then the daughter came in and said she is taking over and she has fired her attorneys and she's going to report them to the Law Society. And with me, the insurers thought, you know, we're wasting time and money on this file. Can you just give them a nuisance offer to go away? We offered about, I think it was 300K, and the daughter came back and said she wanted 1.2 million. And the merits are good for the doctor here in this matter. So I suppose for you, Fia and Nadia, it becomes difficult because you know you have a good defense case, but the plaintiffs are just running up costs, and eventually you have to come to a stage where you need to make a decision whether you're going to carry on or just give them something to go away, because sometimes it actually costs more money keeping the matter alive. But that's a commercial and business decision that insurers need to take. Justin, what's your longest one?
I was thinking about it, Sandra, and I think you and I are tied, because mine would also be about 16 years. The cause of action arose in 2004. And I think summons was issued in 2007, and it's still not been adjudicated in a trial. It actually took place in a coastal city, and I know for a fact that the plaintiff has exhausted all the attorneys in the entire province. So she's currently advertising online for attorneys that want to take her case. But yeah, talk about poisoning the well.
Yeah, we do get weirdos, but that said, I mean, I always say that there are lots of cases out there that are deserving of compensation, and we just have to find the right ones and to deal with them properly. I mean, we always say when there's a liability exposure, we're very quick to tell insurers, and then we quantify the matter properly, and we give the plaintiffs what they deserve where there has been genuine harm.
All right, thanks, Justin and Sandra. I'm just going to ask both of you to just take us through the strategies to reduce litigation risk.
Last start, Sandra, or are you good to go? Oh, you're muted.
You want me to take that?
No, I just wanted to say, are you want to start and I'll complete your sentences?
Okay, yeah, perfect. Okay, so record keeping is key. I mean, that's obviously goes without saying. as we've said from the start, you can have a good case, but if you don't have the evidence for it, then it's a non-starter. So that it's very important, and it must be. Please tell your doctors it must be legible, it must be clear, and because we need to understand. And remember, sometimes these things have happened a long time ago. They see so many patients all the time. They don't remember what the patient was about or what they wrote. Hopefully they can read their own handwritings, but it makes it very difficult for us as lawyers to assess a matter if we can't see what's written on the record. And as far as possible, please advise them to keep electronic versions as backup. Because records get lost. We know that there's fires, things happen, they get lost, there's fires and a host of other things. But if they have an electronic version on board, then at least we've got that backup. What else did I want to say about informed consent?
Record keeping. We attended a seminar with the district attorney for the Department of Health pre-COVID. And one of the challenges that state has is that they can't find records. And if you were looking at what a hospital record looks like, I remember Justin was on the news a few years ago, and he showed what a record room looks like. We always say that record keeping is the best ammunition. We can't provide any defense without the records. We recently did a seminar as well on our road shows where we said it's the best defense, and it's always about keeping those records on time. And if you can't immediately update it, use a device to record your notes, and you can use that. Technology has allowed for that. So it's about empowering our practitioners and institutions to make sure that they do have the proper records in place.
Yeah, no, I mean, absolutely. I couldn't have said it any better. I mean, we always say record keep. That's why it says record keeping is key. It's very, very important. And even whether you have a good case or bad, if you have a bad case, then you need to know upfront, and those records are a telltale. Justin and I did some work for the state on the medical malpractice work for one of the provinces. My gosh, such a headache because there are no records. I mean, for cerebral palsy kids, for gynecologists and obstetricians, where you would expect everything to be jotted down, the tracings of the baby's heartbeat, nothing. And sometimes they have good cases. Sometimes there was no negligence, but you can't, without the records, you can't prove anything. So yeah, definitely, Pia, you can't overemphasize the importance of record keeping. Informed consent is a topic on its own. Maybe I will just deal with that with internal protocols and processes. And that speaks to try to keep abreast of the developments that affect the profession, because there are laws, they're always changing. The HPCSA rules and regulations are always changing. There are new directives. The trending law at the moment is POPIA, the Protection of Personal Information Act, and that speaks to informed consent as well. There's a whole chapter dedicated to the importance of informed consent. I mean, if you read that with the National Health Act and with the Health Professions Act requirements on informed consent, that's very important. So keeping abreast of the developments in the law is good, and you don't need to get into any detail. Just understand. I know how busy doctors are, but just the basic understanding of what they need to comply with, and then put protocols in place as measures to help them comply. And if it's a medical facility, then train your staff on that sort of thing. I promise you, it can avoid a lot of problems. I see, Justin, I'll let you deal with never be bullied and patient communication. Patient communication. I'm not suggesting that you are bullied.
No. Yes, look,
but before you do, sorry to interrupt you. Before you do, I just wanted to add another thing that's not in the slide. And I suppose I'm talking to the converted here, insurers and brokers. But the importance of having professional indemnity cover cannot be underestimated. It is so important. And keep continuous cover so that you renew every year that it's supposed to be renewed. I mean, there's nothing worse than being, any professional, there's nothing worse than being sued in your professional capacity. But then you have to contend firstly with litigation costs, with the legal costs, which can be massive. And you have to then contend with a possible adverse damages award against you. I mean, for a CP case, for example, sorry, I keep talking about CP, cerebral palsy cases. That can be anything between 20 and 30 million. I mean, that can break your practice if you were to pay that, as a doctor, that is, if you were to pay that off from your own pocket. So brokers, please encourage your your clients to make sure that they renew their policies, because that's half the battle won. You don't have to worry about litigation costs, and if you are found liable as a doctor, then you have your insurer to cover you. Yeah, sorry, Justin, I interrupted you. Will you carry
No,
on?
not at all, but using that as a jump off point, Sandra, in addition to making sure continuous coverage, is also important for brokers to evaluate the levels of cover that the insured needs per period. And that sounds like an obvious underwriting issue, but that involves inquiring from doctors and medical professionals, just what work are you doing? Because, you know, medical technology is changing all the time. They introduce a new procedure, they go on an extra course, they go overseas on a fellowship, they come back and they implement those practices and procedures in their practice for reward. Those influence possibly the levels of cover that they need. So one must also not be caught short on that aspect with levels of cover that are insufficient, because remember, at the same time, the medical technology also comes to the claimant's aid in a medical malpractice matter, because the availability of those technologies means that the size of claims is likely to escalate in the future. We've seen that already over the last 15 to 20 years. So yes, that's important. And that brings me to the next important, very important, it's right up there with record keeping. One of the primary reasons why, and studies have shown this, why patients tend to sue is lack of communication. We're not all born communicators, but that being said, because of the imbalance of power, the bargaining power and the knowledge deficit between a medical professional and their patient, it's even more important that we pay attention to how we communicate with patients. And yeah, oftentimes patients won't tell you what they're thinking unless you specifically ask for feedback, whether verbal or in writing. So patient satisfaction is very important. Studies overseas have shown that those that have had a negative, leave a doctor's rooms with a negative impression are 10 times more likely to sue, or whatever the statistic is. And that includes the next point, which is sometimes when things go wrong, there's no stigma or shame attached to apologizing. It's a terrible habit that we have of thinking of an apology as an admission of guilt or liability. It's not. It rather goes to show that we are human. And so there are ways and means in which one can apologize for things that have befallen a patient that does not constitute an admission of liability. We always say, if you feel inclined to apologize for a bad treatment interaction with a patient, do so, but do so carefully and make it clear that you're empathizing rather than admitting any guilt or that you're liable for any legal consequences. So yes, oftentimes if it's important enough, a doctor will actually contact his insurer or seek legal advice in order to make a formal apology. And oftentimes we see nowadays that is a prequel sort of to a mediator process whereby no summons eventuates, no litigation follows. Just because the patient got an opportunity to be heard, as we said earlier. There was sort of a look back discussion, and yes, so that closure is very important in the medical context. And yes, now we come to the bullying aspect. The other thing is doctors might be forgiven for thinking nowadays that just because an attorney has written them a letter requesting their records or sent them a letter of demand or demanding some obscene amount of money, that it means that they must just pay. Don't be bullied into making payments or concessions. Always notify your broker first and seek legal advice second. Remember, legal liability being the trigger under your PR policies is something that needs to be proven. There's no such thing as the facts speak for themselves in our law governing MedMal. So it's something that needs to be proven. And so one does not just roll over and play dead when you receive a sternly worded letter from an attorney. Notify your insurer.
All right, thanks, Justin and Sandra. Fia, would you like to weigh in from here?
I think for us, you know, we are in the matter of medical malpractice. We intend to and continuously wish to ensure medical malpractice in the long run. So where possible, in order for us to manage and mitigate risk, this is key for us. And it's about education to our brokers and education to our clients. And that's what we're here for. And we're happy to have conversations with clients. We're happy to engage and have continuous ongoing risk mitigation to mitigate against losses in every single instance. And like Justin has mentioned, patient communication, informed consent, record keeping. I think I can write a complete whole thesis on the three in future, but please always remember those 3 key points. And then from Nadia, is there anything that you'd like to add?
Yes, definitely. Looking forward to your thesis in the future. If anything that I can just add is, when an insured or practitioner receives any kind of approach, legal documentation or anything, you know, they should just make sure that they never ignore it and always notify your insurer. If there's any doubt about, you know, notification or whether they should or they should not, we're just a phone call or an email away. Call us. We're always here to render some kind of support, assistance, and guidance. Pia and I normally have this line where we joke about notification. We always say, don't be shy and notify. So that's our line from the Kim side. So thank you very much from my side.
Thank you. And just a thanks to Justin and to Sandra. And just to give you some exciting news, we have launched the 10-minute expert videos. Please go take a look at our iTOO YouTube channel. There's quite a few informative 10-minute expert videos, just enough to keep anybody entertained and not to keep them too bored. We appreciate all of you. Please take a look. Justin, Sandra, we love you guys, and we hope to see you on more iTOOsdays.
Thank you,
Being with you all.
everybody.
Thanks, everybody.
Bye.
Bye.